Hello friends, in the series on the income tax cases, today we will discuss an issue, and the issue is that whether the Commissioner of Income Tax Exemption has the power to cancel the registration of an assessee without doubting the genuineness of the activities of the assessee, or where the assessee has performed its activities as per the objects of the assessee, or in other words, whether the Commissioner of Income Tax Exemption can deny or cancel the registration of the assessee simply on the ground that the assessee has changed the nature of the donations from corpus to the general donation. This issue has been taken up by Honorable Calcutta High Court in the case of Commissioner of Income Tax Exemption versus Gobind Ram Gopal Charitable Trust. This matter is reported in 474 I.T.A at page number 568, and the date of the judgment is 25th June 2024. In the present case, the assessee has received the donation from a donor, SHGPH. Earlier, the assessee has treated these donations as corpus, but after that, the assessee changed its stance by saying that these donations are not corpus, these are general donations, and the assessee was agreed to pay the tax by treating this donation as general. The Commissioner of Income Tax Exemption cancelled the registration of the assessee on this ground that the assessee has changed the nature of the donations from corpus to general donations. The assessee filed appeal against the cancellation order into the tribunal, and when this matter was heard by the tribunal said that in the present case, Section 12AA subsection 3 is applicable. Section 12AA subsection 3 says that the registration of the assessee under Section 12A can be cancelled by the Commissioner of Income Tax Exemption only in case where the activities of the trust are found to be non-genuine by the Commissioner of Income Tax Exemption, or the activities of the assessee are not as per the object of the assessee. The tribunal said that in the present case, the department does not dispute that the donations received by the assessee are general. It does not matter that the assessee has changed the nature of the donation because the assessee has paid tax according to that. The tribunal said that the Commissioner of Income Tax Exemption has not given any finding disbelieving the application of the fund by the assessee towards its object. The tribunal said that the assessee has provided the details of the application of the fund and the details of the donations received by the assessee from SHGPH. The tribunal said that the donations were accepted as general donations by the tribunal and were subjected to tax in the hands of the assessee. So, the tribunal cancelled the cancellation order of the registration passed by the Commissioner of Income Tax Exemption in the case of the assessee. The revenue filed the appeal against the order of the tribunal challenging the cancellation order of the Commissioner of Income Tax Exemptions, which was reversed by the tribunal. And when this matter was heard by the Honorable Calcutta High Court, the court said that in the present case, the findings have been recorded by the tribunal, and those findings are findings of fact and they do not involve any substantial question of law. And the court said that there is no illegality or perversity in the order of the tribunal, because in the present case, even the tribunal has reproduced the detailed application of fund by the assessee and the details of donation in the order passed by the tribunal. And since there was no disbelief by the revenue regarding the objects of the assessee, so whatever the order has been passed by the tribunal in cancelling the order of the C.I.T. exemption, that is justified. At the end of this video, once again I am repeating the name of the case. The name of the case is Commissioner of Income Tax Exemption versus Gobind Ram Goel Charitable Trust, and this case is reported in 474 I.T.A at page number 568, and the date of the judgment is 25th June 2024. Thank you, friends.